So our third snippet and final snippet for this week looks at the constitutional history of the gay rights movement, which begins in the 1980s with this crushing defeat before the Supreme Court in a case called Bauer versus Hardwick, where the court had ruled that state laws criminalizing gay sex were legal. But then we have a swing against in 1996, a decision that we talked about in one of the sections on Monday, a case called Romer versus Evans. The court strikes down a Colorado law that prevented cities in Colorado from adopting anti-discrimination laws as they applied to gay and lesbian citizens. That case was called Romer versus Evans. The author was Justice Anthony Kennedy. And in 2003, the court decides to reconsider this Bowers decision in a case called Lawrence versus Texas. The decision is 6-3, but only 5 justices join the majority opinion, which again is written by Anthony Kennedy, who's written all of the major gay rights decisions in U.S. History. The court strikes down, reverses Bowers in its entirety, strikes down the Texas law, says there can be no criminalization of gay sex. And has this sweeping language from Kennedy that basically says that at least in this context, it's quite true that the framers of the Constitution and the authors of the 14th Amendment could never have envisioned a society in which gay and lesbian people wanted to live openly and equally, but they articulated principles, and you must apply those principles to changing historical context. And at least in this case, Justice Kennedy argues it is perfectly reasonable to make this approach. Lawrence is very clear that it doesn't apply to marriage. It says, we're not striking down marriage laws. We're simply striking down laws that criminalize consensual sexual contact between adult citizens of the United States. It nonetheless generates a ferocious dissent from Justice Scalia, who actually correctly predicts that the opinion, by saying that the key holding of Lawrence is that states, simply because they consider gay or lesbian relations to be immoral, that's not enough you can't just pass a law saying we think you're immoral and so we're going to make your behavior criminal. Scalia senses that the ramifications of that decision eventually are going to lead to the recognition of same-sex marriage, and it turns out he's correct. Lawrence will be cited in the Obergefell decision. So what's going on here with regards to marriage, which is the big constitutional issue for gay and lesbian Americans? Majority of Americans oppose same-sex marriage through the mid-2000s, and the flip only occurs in 2010, 2011, where small majorities, and then becomes a very, very large majority in recent years. But in 2004, Massachusetts becomes the first state to legalize same-sex marriage, and that's important because the opponents of same-sex marriage would often made a number of predictions. So, it will lead to the deinstitutionalization of marriage, or the massive persecution of religious people who oppose homosexuality on religious grounds. And those predictions generally don't come to pass in Massachusetts, and other states will gradually legalize same-sex marriage as well. But still, in 2004, let's go to the chart here, a majority of Americans oppose same-sex marriage. And so in the 2004 campaign, Bush's chief political advisor, this man Karl Rove, comes up with the clever idea of placing state constitutional amendments on the ballot in all these states that I have in green on this map. And the goal is to get conservative Christians out to vote for the same-sex marriage bans, and assume that they will also vote for Bush for president, which they do. And the big three here are Oregon, Michigan, and Ohio. These were sort of the swingy states in 2004, and both Ohio and Michigan, will sort of be will be the most significant states. Ohio goes for Bush, and that's enough to clinch him the presidency. And critically, by placing these bans in state constitutions, the effect of these Roe referenda is to ensure that gay and lesbian couples, if they want the right to marry, basically are going to have to go to federal court, because if your state constitution says something is illegal according to the state constitution, the state Supreme Court can't overrule the state constitution. So everything gets pushed into the federal courts. California is the second state to legalize same-sex marriage in 2008, but that decision is overturned by a state constitutional amendment called Proposition 8. And a reminder, this is only 12 years ago, how quickly public opinion has changed on this matter. Barack Obama comes out, he technically opposes Proposition 8, but he also says openly that he is not in favor of gay marriage. His image is used on the Yes on 8, so this is the anti-same-sex marriage side campaign, and the critical voting bloc in the race are African American voters who are overwhelmingly Democratic, but also are more religious than white and Asian voters, and they vote 7-3 in favor of the ban. The other Democratic group that votes heavily in favor of the ban are suburban white women, who are sort of swayed by the advertising campaign of the Yes on 8 side that suggests that if same-sex marriage is legal, that it will be taught, and the idea of gay sex will be taught at elementary schools. And this argument is the only way you can control your kids' education is by keeping this illegal. So the net effect of this is to push everything towards the federal courts. Although same-sex marriage gradually does legalize. By the end of 2012, all of the states in the Northeast have legalized. Maryland has, Iowa has, as a result of the Supreme Court decision, and Washington State in the West. And the first of the two big decisions with regards to same-sex marriage is a decision in a lawsuit brought by this woman, Edie Windsor, whose wife had passed away, and who was then hit with a massive estate tax bill, which would not have been the case if the federal government had recognized their marriage. But the federal government didn't recognize their marriage because it was a Clinton-era law called the Defense of Marriage Act, or DOMA, which said that for all federal law purposes, the federal government recognized only heterosexual marriages. So the federal government, in this case the IRS, treated Windsor as if she were an unmarried woman rather than being married to her wife, and so she sued, saying, "Look, I've been harmed by this. The law is unconstitutional." And in a 5-4 decision, Justice Kennedy, yet again, votes is the decisive vote and writes the opinion in a very, very strong opinion, in which he says the principal purpose of DOMA is to impose inequality. It humiliates tens of thousands of children now being raised by same-sex couples. Edie Windsor and her wife did not have any children, so children were not really relevant to the case per se. It's clear what Kennedy was doing. He was teeing up the next stage, which would be the marriage, the individual state marriage bans. Windsor dealt only with the state of law in states that had legalized same-sex marriage, but didn't have those marriages recognized by the federal government. What's particularly interesting about Windsor is that there are two very different dissents that are written. The vote is 5-4. Chief Justice Roberts' dissent basically says Windsor is a very narrow opinion. Logic of the opinion doesn't decide the question of whether gay and lesbian couples in states that have banned marriage have a right to marry. Scalia's dissent says that's not so at all, that the logic of the Kennedy opinion is that they're going to strike down these same-sex marriage bans at the statewide level as soon as they possibly can. Roberts was actually tactically smart here. Scalia's dissent will be quoted by virtually every lower court which strikes down same-sex marriage bans in the between 2013 and 2015. And their argument is, look, if even Justice Scalia says that Windsor says that these bans are unconstitutional, who are we to argue with Justice Scalia? So this is the state of affairs when the Windsor decision comes down. All of these states in green have legalized same-sex marriage. The California Proposition 8 was successfully overturned in federal court. So we see more states permitting it now, not just the Northeast, but some states here in the Midwest, Illinois, Minnesota, Iowa, and then Washington, California, New Mexico, and Hawaii. In every other state, in all the states here that are tan and yellow, there are legal challenges in federal court to their state's same-sex marriage bans beginning in late 2013. But the first same-sex marriage ban that falls is in a state that no one would have guessed, in Utah. The case is called Kitchen versus Herbert. The decision is written by this man, Robert Shelby, who's a federal judge in Utah, and it strikes down the Utah same-sex marriage ban. And the key clauses of the opinion, which I have quoted here, he's very much influenced by Kennedy, and you can get a sense of Kennedy opinions here. Now, when a state law is challenged, usually the state makes a request to the judge that he or she stay their opinion. Stay means to postpone the opinion, just to allow the state time to appeal the opinion. But the Utah Attorney General's office forgot to ask for a stay. And Shelby said, "You didn't ask. I'm not going to give you one." And the result was that his opinion went into effect immediately. This was just before Christmas of 2013. And this is a photograph of the Salt Lake City county office. And you have all of these gay and lesbian couples who rushed to the county office because they wanted to get married. The hope is, the fear is that the state is going to be able to persuade Shelby to grant a stay, or maybe the appeals court. It turns out it takes 17 days for a stay ultimately to be issued. It's not issued until it gets to the Supreme Court temporarily issues a stay. By that point, more than 1,000 couples had been married in Utah. And the sense here is that because federal courts allowed these people to be married, it's probably likely in the end the federal courts were going to recognize a right to same-sex marriage. They do so gradually. In 2014, the Supreme Court declines to hear a number of appeals from decisions that had struck down same-sex marriage bans. And because the court basically then blesses them, although without an opinion, all these states in green have the right to marry for gay and lesbian couples by 2014. But finally, there's a single appeals court right here in the middle part of the state, the Sixth Circuit, which upholds the same-sex marriage ban. So that works its way up to the Supreme Court. The court holds oral arguments over the ban. You can get a sense of the arguments that are offered here. The lawyer representing the states basically says the purpose of marriage is procreation, and it's to protect children. And Justice Kennedy seems very skeptical, because basically he says, gay and lesbian couples are raising kids too. So even if the purpose of marriage is children, why would you deny it to gay and lesbian couples? And then Birch, the lawyer representing the states, makes a critical mistake. Kennedy was, as a justice, big on the idea of dignity. This was a theme throughout Kennedy's jurisprudence in all kinds of different issues, that it was very important that the government respect the dignity of individual citizens. And Birch, in his comments, has this throwaway line of, well, marriage doesn't bestow any, if a state allows a couple to marry, that doesn't bestow any dignity on them. And you can see here down at the bottom of the transcript, Kennedy is going to have none of that. So it's clear after oral argument, Kennedy is going to rule in favor of the couples. And he does in 2015 this famous decision called Obergefell versus Hodges, which says that same-sex marriage bans harm the children of same-sex marriage. So even if we accept this Birch definition of marriage, the sole purpose of marriage is to protect children, which of course it is not. But even if we accept that, Kennedy argues, because gay and lesbian couples are raising kids, and because the right to marry has long been seen as fundamental by various other Supreme Court decisions, we're going to apply it to gay and lesbian couples as well. for conservative justices dissent, but this becomes law of the land, and it's really become, this is a decision that's only 5 years old, but it's essentially settled law now, and there's no chance of it being reversed. So that's all we have for the snippets for this week. Hope everyone is doing well, and I will talk to you on Monday.